welcome to What's the Tea in L&E. I'm Emily.
And I'm Leah.
And we have a special guest with us today.
I'm King.
We finally convinced someone other than Leah's dog Van to do this with us.
That's right, yeah.
So guys, what are we here talking about today?
We are talking about a breaking new rule from the Federal Trade Commission. What is a Federal Trade Commission? This doesn't feel like an employment thing.
Well, ordinarily the Federal Trade Commission regulates advertising and things like that, unfair business practices, but we have breaking news that they have issued a new rule that affects employers.
On non-competes. What is a non-compete? A non-compete is basically a provision in a contract that an employer would execute with an employee that basically says while the employee is employed with them, the employee cannot engage in competitive business, right? That makes sense. And as well as after employment, that the employee for usually a period of time like 12 months, maybe up to 2 years, would not engage in a competitive business with the employer.
Absolutely. Yeah, when I worked in sales, these were very common. Almost everyone had them in their contracts. But that's what's about to change because the FTC has just issued a final rule that says that non-compete provisions are largely illegal according to the FTC. Do you think that will stick, King?
I don't, is the short answer. I think that there has already been a legal challenge filed. I think that there is a real question about whether the law that created the FTC has truly delegated to them the power to just issue this directive that all non-competes in all states are banned. All the states, including Virginia, have had a trend towards raising the stakes and making it more difficult to enforce these. But that sort of state-by-state enforcement has a long tradition, and I think that the courts are likely to give serious consideration to the argument that FTC can't do this without further congressional intervention.
But even so, right, if it gets held up, King's prediction, he's going to put money on it. What are employers to do? They could arguably do nothing right now and keep using non-competes and moving along and seeing if it gets held up in litigation, right? And when you do execute those non-competes or put them in place, make sure they're narrowly tailored to state-specific rules, things like that. They could already start complying. But what are some alternatives they could do right now?
Well, I think that one thing I've seen some employers say is that they want to reevaluate who they give non-competes to anyway. And so there is, even under the rule as it's written, there is a period of time before it goes into effect. So you've got from now until August. You will probably find out what the courts think during that period of time. And so we think that some employers will choose to do nothing and wait to see, but others may start to scale back on who they give non-competes to.
And worth noting, we are a Virginia-centric firm, and Virginia already has a state law in place that prohibits non-competes for low-wage workers, and low wage might not be as low as you think it is. The law applies to anyone earning, I think it's about $68,000 or $69,000 a year or less. So keep that in mind if you're in Virginia.
Yeah, and there's other ways around this too, not around it in a sense, but you still have the right to protect your confidential information once an employee departs. And there may be some wiggle room with non-solicitations. We'll kind of see how that plays out. But before you try to execute one of these right now or go ahead and try to enforce one, make sure you talk with counsel.
Absolutely. Well, thank you for joining us for another What's the Tea. Thank you to our special guest, King, and we'll see you next time.